game because I'm feeling inadequate already. Take a look at her bio. She's really accomplished a lot in just 10 years out of law school. Has her own firm in Detroit. Excuse me, Lansing. There's too many Detroit people here. And she's going to talk about evidentiary issues, but there was a case that came out last week, 2 weeks ago, when I was elsewhere. Keith asked me to read it and incorporate it into my introduction, and it's called Kuhn with a K. It's out of Michigan, and as we've heard at this conference in the past, Michigan had a crappy law about if you find THC in someone's blood, you're guilty of DUID. I think, am I oversimplifying that? I think that was the law for a while. Okay, I got a yes and a no for that. Mary's going to talk about the Kuhn case, and I will summarize the Kuhn case when she got the Michigan Supreme Court to say, not so fast. You have to prove the guy was actually stoned. She did graduate summa cum laude from Cooley Law School in Michigan. I don't even know what that means, but it's probably pretty good. She does teach there, and let's make her feel welcome, and hopefully we'll have her at all the rest of the NORML conferences. It's my pleasure. Mary Chartier.
Jerry was like so twisted up back here, so in case you were wondering what we were doing behind his back, we were like getting her cord out.
Is my mouse there?
Wait, is this your little mouse?
Yeah.
Cool. Okay, good. I know I stand between you and a fun afternoon in Aspen, so I'm really just going to try and hit the highlights. So don't worry, I won't bore you too much. I was asked to talk about Kuhn, which is a medical marijuana case that came out last week from Michigan. So essentially what happened is Michigan had a gentleman named Rodney Kuhn who was a registered qualifying patient. He had a card, and he was stopped. He had THC in his system. Both the district court and circuit court said it's an under the influence standard, which is in the MMA, which means that you can't just convict somebody based on THC in his system. The case went up to the Court of Appeals, and they reversed that, saying if you have any amount in your system, you are under the influence if you're a patient, and you can be convicted. It's actually kind of interesting is I spoke at the Michigan Judges Conference with my business partner, and the judge, Judge Rogers, who wrote the circuit court opinion, was in the audience, as well as one of the Court of Appeals judges, who's a really good friend of mine, and they were like, well, he was really like kind of bashing this opinion, and I actually felt really bad for it, even though we were appealing it to the Supreme Court. So anyway, we appealed to the Supreme Court. We won unanimously, 7-0. I found out last night while I was drinking my wine that they dismissed the case against Mr. Kuhn in its entirety. So he's really So that was a good victory for us in Michigan. And I will say I like the altitude here too because it makes the wine like it has a little effect more than you would get in Michigan. So Matt Abel is here and Dan Groh, two great guys who have helped prep for another case that was at the Michigan Supreme Court, which we were not as successful on. We did get the court to say that you can sell marijuana in Michigan, which was hilarious to us, but you can't distribute it. So if you can figure out a way to sell it without possessing it or distributing it, you're golden. But that was our opening that we wanted the court to reach that holding, and they did. So anyway, I am here to talk about evidentiary issues. I know my time is limited. If you have questions, please feel free to ask them as we go. If you're like me, I forget. If you wait till the end, I'm like, gosh, I knew I had a question. I forgot what it was. Evidence, I know, is not the sexiest topic on the agenda, but for those of us who are in the courtroom all the time, it's wildly important. I represent Barbara Agro. For those of you from Michigan, you'll know who she is. She's a now 75-year-old woman who is a convicted felon because she was growing teeny tiny little marijuana plants in her basement for both herself and her husband. Her husband actually died. That's how sick he was during the course of her trial. She was convicted at trial. She wasn't allowed to raise her medical marijuana defense, even though she was a card holder. I handled her appeal. We won at the Court of Appeals, going back down to the circuit court in Oakland County. Dan, is Oakland County a friend to medical marijuana cases? No, they are not. Even the judge called us up because we have a hearing date in August and said, why are you spending money, to the prosecutor, like convicting some 75-year-old woman who had worked at the sheriff's department, has no criminal history whatsoever, foregoing these little teeny tiny plans. And they said, you know, we're tough on crime in Oakland County. So that's their, so, right, so don't, if you're a medical marijuana patient, move out of Oakland County if you're in Michigan. But evidentiary issues are obviously huge. They're going to be huge to us in that case. Again, to me, prosecuting some 75-year-old grandma is crazy, but they're doing it, and they're battling with us over every single thing that we need to put into evidence on her medical history, her husband's medical history. I mean, it's just crazy. So it's going to be a bit of a bloodbath. She's a great client, and she is super feisty. So, you know, I have every belief that we'll get a good outcome one way or the other. So anyway, today we're just going to hit on some highlights of really kind of underused or misunderstood evidentiary rules. The first one that I love, and I actually did a whole hour on this, but don't worry. In the front, they're all nervous. I won't do a whole hour on it, is hearsay, truth of the matter asserted. And so often when we're in court, you know, you'll get that hearsay objection, and then the judge is going to rule one way or another. But it is such a friend to us because we get to keep a lot of stuff out. We get to admit a lot of evidence that we want in, if it's for a reason that's not truth of the matter asserted. If you're a defense lawyer, and I know there's no government folks in here, so it's a nice audience, bias, motive, effect on the listener are our perfect three reasons why we want evidence to come in. I had a case in federal court where my client looked at 30 to life for a drug conviction, was getting, well, if he had been convicted, was getting letters from some potential witnesses. And in there they said, Donald Davis is going to fuck you unless you plead in this case. Donald Davis was the appointed U.S. attorney for the Western District of Michigan, a more conservative gentleman you would never meet. And so if you knew Don Davis, reading the very graphic stuff that was in this letter was hilarious. We wanted the letters to come in to show the bias of these witnesses. The AUSA kept saying they're hearsay, and we said no. You know, it's not for the truth of the matter asserted. We have no belief that Don Davis is going to take my client out on Saturday night and, you know, ride him hard and do all this other stuff too. I mean, right, that's not going to happen. Well, he kept arguing, yes, that's why we wanted to put it in. The judge got so frustrated. At first he thought it was funny. Then he said, do you realize what you're saying? You're saying your boss is planning on having sex with Mr. Smith? You know what I mean? This is crazy. So the letters didn't come in for another reason, and we won the case anyway. But the truth of the matter asserted is such a concept that we can use, it's beneficial to us, that a lot of prosecutors and government folks don't understand. Now, prosecutors will frequently try and use that concept to get background evidence in. So they'll say to the officer, you know, why did you investigate Mr. Smith? And they'll say, well, gosh, 20 people told me Mr. Smith is a drug dealer. So, you know, but we're not saying that's truth of the matter asserted, that's background. That's why he did it. There's a really great case out of the Seventh Circuit, which is in your packet, called Mancius, which talks about essentially that's baloney. Background information is subject to the same confrontation issues as any other type of information. If you say 20 people told you Mr. Smith was a drug dealer, great. Bring all 20 on in. I'm prepared to cross-examine them. You don't have to explain why the officer started investigating Mr. Smith. All you have to do is say he started investigating Mr. Smith. So there's a really good case out there, and there are other cases as well, to challenge that coming in. And that actually was happening, I think, last week with Tom Loeb, who's another really great Michigan lawyer. So anybody have a question? I'm mindful of the time. I know you want to get out of here. Along the same lines is the concept of implied hearsay, which you probably all have used, even though you shouldn't. And you may have seen the government try and use it, and they really shouldn't. And that's because the court sustains your objection. AUSA can't get the background information in. So they say, okay, you're not going to be able to testify as to what these witnesses told you. And so now what they say is, officers friendly, you didn't have a suspect before you went to interview Mrs. Smith? No. You interviewed Mrs. Smith? Yes. When you left Mr. or Mrs. Smith's house, did you have a suspect? Yes. Who was it? And usually they'll say, you know, Ms. Chartier's a very guilty client. That's a concept called implied hearsay, which they cannot use. It's the same thing that they're trying to get in through the back door that they can't get in through the front. they're trying to get in what Mrs. Smith said. Either she identified my client or my client told her stuff or whatever. And I've used that for myself, you know what I mean? And I feel like, hey, if they're not objecting at the other table, that, you know, all is fair. But we should be objecting to that coming in, because that is an extremely common tactic that they use. And they shouldn't be. And there's another great case called Reyes out of the Second Circuit in your handouts, which talks about just this. The whole goal is for that jury to believe that Mrs. Smith provided evidence against the client. And it can't come in without that person there. All right, anybody have questions? Or I know, hearsay, I know, generates a lot of excitement, right? Okay, so you're just processing it. It's so great. Oh, go ahead. Yay, somebody has a question.
What's some good examples of case law for the truth of the matter asserted?
In your packet I gave you, I think it's like 20 pages, right? I'm sure you've all read it. You know, like that's what you were doing last night. And there's all right, and then I didn't hear anybody on their balcony. And there's some cases in there on truth of the matter asserted, so if you want to take a peek at it, it's probably more than you'll ever want to know on that concept. So the other issue as it relates to hearsay is it also can be nonverbal. And so you get a lot of this with gestures. The head, I got a head nod right now, right? If it's intended to be that this gentleman agrees with me, that's hearsay, and that can't come in. And I always seem to have, you know, the person who's pointing, the guy went that way or whatever. All of that stuff is hearsay, it can't come in. Shoulder shrugs, gestures, all of that you should be objecting to. And again, in the interest of time, all of this cases on every topic are in your handout, as well as stuff that we won't even talk about today, right? Another, beg your pardon?
It's an added bonus.
I know it's an added bonus, right? So you get to have fun and then read this in your free time. Another concept to consider when you are making your evidentiary objection is, especially if it's hearsay, it's not just evidence, it also can violate the confrontation clause. And who would think Justice Scalia would give us this great gift in Crawford? I mean, he's the same justice who doesn't like actually innocent people being able to challenge that. You know, he says, listen, stay in prison, go to the chair, it doesn't matter that you're actually innocent. But I'm going to make sure that the evidence that comes in doesn't violate the Sixth Amendment. So you take the good with the bad. Crawford, if you have hearsay, it's not, you want to make that objection, but you also want to preserve that constitutional element. Because if that person isn't there, you can't confront that witness. And this is a fun thing, too. Anyone ever have a prosecutor who cries that they have a confrontation clause right? Right, which is something, I know, you really want to like pick out your Constitution and read it in there. No, they don't. They really don't have any of those rights at all. It's the accused, you know, which is just fascinating, and I love it. They get all so tense about it. But Crawford gives you this great gift in that, again, it's not just hearsay coming in under that inherently trustworthy standard, which we had in Michigan, which was just nonsense. It has to be something that either is reliable in terms of having existed at common law, which is dying declaration, and pretty much that's it. Or your client has to have had an opportunity to cross-examine this person on the stand before. And usually the way around that is, in Michigan, your prelim is 14 days out from your arraignment. Gosh, you haven't even investigated the case, so you just have to show we have all these other issues we would cross-examine on. Crawford is really a gift to you, and to me, I think especially, and has made domestic violence cases in particular, it's really changed the landscape on that. Some things that aren't hearsay would be, what did somebody tell you? So I know Dan, I don't know very many names, obviously, but I know Dan Grubb. If somebody tells me that Dan likes to rifle through purses when no one's looking, and he does, right? He's a little creepy that way. So let's say that Paul tells me that, and then I go out and I left my purse back there, and now I'm missing money. So of course, I think Dan, he's the only one who would do that. So when I tell that to the police, what Paul told me isn't necessarily hearsay, because I'm not using it for truth. I'm using it to show, hey, wait a minute, this had an effect on me. Now, of all these people in here who I don't know, Dan is the one I'm zeroing in on as the creepy purse guy. You know what I mean? And then he will, sue me for defamation later. So if it's an effect on a listener issue, that's not hearsay. Because we don't care if Dan goes through purses or not. All we care about is the effect on me. That's how he became my lead suspect. And likewise, what did somebody say to you as it relates to bias or motive? Bias is always relevant. There's a great case called Davis versus Alaska from the US Supreme Court that talks about you have such a broad cross-examination right. And bias, really, of that witness is something that we all should be exploring. In federal cases, what's usually the reason they're testifying?
They're a snitch.
Right, they're a snitch.
Filthy snitch.
And they get, a filthy snitch, not just a snitch. They get tremendous time cuts, both before and after. I mean, is it any surprise a key witness against my client was given life in prison? Gosh, now he suddenly remembers that my guy was involved every step of the way. You know what I mean? And now he gets a decrease in his sentence. All of that goes toward the bias and motive of that witness. All of it is fair game for us to cross-examine. There is, prior arrests is another thing. Again, usually courts will say, propensity doesn't come in. If you argue bias, then it can come in. Bias can allow you to get in a lot of things that you normally would not. Michigan has a concept called the doctrine of chances, which is ridiculous, and it's used against defendants to show, like, how many times can your house burn down? You know what I'm saying? Before, like, you're the guy who's setting it on fire. But you can spin that around for witnesses. How many women take out PPOs? You know, like, really? I mean, in my little, life, I've never taken out a PPO. I've never been sexually harassed. You know what I mean? None of those things. When you have a witness on there who's claiming your client raped her, or she's got a PPO, or all this, how many times has this person done that? And then, again, we argue doctrine of chances. And then you argue to the jury, especially during voir dire. How many times have you ever had to take out a PPO against somebody? Most of them will say never. You get somebody on there who's claiming 3, 4, 5 times, they start to think the same thing you do. This is just this person's MO. There is 404B, more stuff than you would ever want to know in your packet on 404B evidence. Michigan has not been that friendly to defendants. Federal court hasn't been that friendly, at least in the Sixth Circuit. They allowed, in one of my cases, a prior drug dealing conviction to come in because they said that there was a similarity of the MO. 15 years prior, my guy had been on a motorcycle with drugs in his backpack. 15 years later, he was alleged to have transported drugs in a car. The judge said, see, they're both motor vehicles. That's his MO. Which, I don't know too many guys who are transporting kilos of cocaine by walking. You know what I mean? So it really opens it all up. We still wound up winning that case anyway, despite this ridiculous ruling. But at least in our little section of the country, it's been a little tougher on defendants than we would like. When that stuff comes in, I usually try and bring it up to the jury right away. And in my case, I said, get the guy on the stand, essentially, what did you do the last time? He confessed right away and took a plea deal almost immediately. In this situation, he talked to the police, told him he wasn't involved, and actually went to trial. Juries tend to respond to that. Look I've done bad stuff, you know what I mean? And when I do, I plead out. But I didn't do this, and I'm not going to plead out. And again, that seems to be something, at least, that juries have responded to. Reverse 404B is a concept I think that is underused by defense lawyers, and that's just 404B evidence against someone who's not the defendant. The standard for that is significantly more open for a witness. So the concern with the defendant is, gosh, you're going to convict him because he's a bad guy. But there's no issue with that with the witness. Witness is not on the stand in terms of facing a conviction. So that evidence should be allowed to come in. And there's a nice case from the Second Circuit called Abu Masalam, and that's in your packet as well. And it talks about that reverse 404B allows lots of evidence to come in against witnesses. And our mantra is always bias, motive, effect on a listener. This situation, it would be bias because it's reverse 404B. and it shows a reason this person's going to lie. I mean, they've been convicted in the past. They don't want to be convicted again. If you've got a situation where in Michigan a former Supreme Court justice is headed to prison because of some bad financial dealings, if this person, for example, in 2 years' time points the finger at somebody else and says, I wasn't involved, we can use that conviction to show, look at, you stated right in the media you were petrified of going to prison. She doesn't want to go again. And I'm not saying she was involved in anything else. But you don't want to go again, so this is going to be the reason you lie and point the finger now at somebody else instead of yourself. All right. Is this so exciting that you say, my gosh, I can't wait to read my packet? Okay, I know. That's right. You went, yay! Oh, woman, and you seem so sincere when you nodded your head. I know, thank you. Your gesture I want to come in as truth of the matter asserted right there. Does anybody have a question? No? Okay. So I'll kind of keep going, and then again, I'm mindful of your time. I don't want to waste it. Oh, great.
Talking to a former public defender in Colorado, the head of the office, he doesn't really, I mean, we call it reverse 404B, but he doesn't, because the rules are different and lax, I mean, he doesn't really think there is such a thing as reverse 404B. It's simply impeachment material. If you had to argue this, can you tell us, you know, kind of, if that's the stance the judge takes, what our best arguments are?
Most judges tend to kind of go back when they hear anything related to 404B. So I actually agree with your colleague very much. I don't call it reverse 404B. That's shorthand that, you know, I think among defense lawyers. If you did a search, a Lexis search in Michigan for reverse 404B, you wouldn't find anything on it because most people don't call it that. But when you start to get arguments about, you know, for example, and you'll get them from prosecutors saying, oh, it's propensity, it shouldn't be coming in, this is what 404B is for. It's good to be able to cite to some of those other cases that do call it reverse 404B and say, look, it's a totally different standard. It's much more relaxed. This should be coming in. Our fear against convicting that person for being a bad guy just doesn't exist. And it's all relevant to bias. But I absolutely agree with that position. But at least in your own head, you should know, you know, kind of the rules. And I've got some cases in there. All right. Oh, yes?
There are some Colorado cases, Bueno and Flowers. Some jurisdictions, including where I practiced a lot, are requiring the defense to give notice as well as the government to give notice. Although I have drafted a motion objecting to that. But sometimes, depending on your case, you may just want to do a full court. This is the 404B that we want to bring in and call it that. Although I think there are some cases where, you know, the court seems to almost want to say that if we're going to do anything to question their everything you do 404B, and that's not what the law says. And there are certain cases, like in self-defense cases, where you file 404B, you need to get into this stuff.
That's a great point. The other thing, too, at least in federal court, is, you know, your requirements in terms of disclosure are vastly different. You know, at least in state court in Michigan, you have to disclose witnesses and everything else. Federal court, at least in the area that I practice in primarily, they're really cognizant of the fact that we don't have to disclose, you know what I mean? And we want to disclose as little as possible. And they really tend to err on the side of allowing you to keep as much private as you want. And so that's why we don't call it reverse 404B, and we always reclassify it, you know, like in our head. But just for conceptual purposes of knowing what the case law is, I put the reverse 404B stuff in it, if that makes sense. Okay, cool. And was there another hand up or no? All right. Oh, gosh, we'll move on. A couple of other things on whether it's impeachment or reverse 404B would be, just as this gentleman said, on snitches. The best thing about a network of criminal defense lawyers is you can always get pattern evidence. And I know Dan was talking about what they do with FOIA. I try and vet everybody I know. Like, everybody's going to be a witness, from the snitch to the officer to this, that, and the other thing. Not only do I like to know what their history is, but I also like to know what ticks them off. You'll be surprised, but some police officers don't really like women cross-examining them. I know, that's a shock. Like, really cross-examining them nice and hard. So it's kind of fun to do it and get these guys rattled. And then, you know, vice versa, they think you're so nice. I get an AUSA to say on the record, oh, Ms. Chartier is so nice. Gosh, I can't imagine her being mean to anyone. Well, you know, that was on like day 2 of the trial. You know, 3 weeks into it, you know, I'm cross-examining their poor agent, and it worked out great for me because the jury really thought I was nice. They didn't know, like, secretly I'm not nice at all. So my husband could tell you that. Not nice, not nice. But snitches, you know, again, and that's where that doctrine of chances comes in. Because really, how likely is it that almost every guy you bunk with is revealing that he murdered his girlfriend? Or, you know what I mean, he's a drug smuggler, or he's a drug dealer. No, the evidence that they're getting is really public record, and that's why the guy is coming in saying this guy testified against me. Same with CSC stuff, same with PPO stuff. All of that is really material. There is a difference between propensity and motive. So you want to make sure that you always frame the stuff you want to come in as motive, and likewise the stuff you don't want to come in as propensity. There's a case I put in there on page 4, which does a great example of explaining the difference. And so if, let's say, Tom, and I hope there's not Tom in here, Tom is on trial for assault, he's committed 3 others, that coming in is propensity, pretty much, unless they can show a link between what caused Tom to assault in those prior cases and then what caused him to assault in the one that he's on trial for. So is it racially motivated? Is it, what is it? Is it guys named Bob? Is it people who dated his girlfriend? I had a client admit to me, I don't shoot just anybody. I only shoot people who do this to piss me off, to show that he was a nice, reasonable guy. And I said, well, good to know, because I'm definitely not going to do that. You know what I mean? That's great. And it was calling him kind of a certain name. So I said, well, good to know. It was a nickname I didn't like. So, right. So it just kind of made me laugh. But, I mean, that's the difference. So if he had shot 10 people before, and there were a lot, that's propensity. But if he shot them all because they called him this unflattering nickname, that kind of comes in as motive. Now, they didn't know that, so they never could make that link. But there is a difference between the two. Stuff you want in is motive. Stuff you want on is always propensity. And then I have just 2 more points, and then you guys can go and enjoy the day. You get a lot of objections over things being collateral or cumulative. And then judges say, gosh, do we really want to go into that? That seems awfully collateral. Well, it's not the topic you're asking questions on. That's how they analyze what's collateral. It's the issue. So we had a witness who said, I know that this happened on such and such a date and time. I was watching NCIS, and this episode was on, and it was a new episode and went into great detail. So when I was asking her all these questions, not just about her eye exam, but about NCIS, they said, oh, this all seems collateral. It wasn't. It went to the identity. Can she really see this guy with her extremely bad vision? And did she really see this guy? Because the NCIS episode was on a week prior to when this occurred. And so it's not her TV watching schedule that we care about, or when is the last time she went to the eye doctor. It's the main core that we're getting at. Can she really, or could she really ID the defendant? And she couldn't. So that's what the collateral analysis is all about. Not the topics that you are asking about per se, but the broader issue. And then one last point to wrap up. Not only do I do litigation, but I do a lot of appellate work as well. I worked at the Supreme Court. And always kind of keep an eye out toward that you may lose. I kind of convince myself in trial that I'm always going to win. You know what I mean? Like, even if it's a dog, once I get going, I'm like, I may actually win this. They get the guy on videotape or whatever else. And I convince myself I have a real shot at this. Even if you are the most optimistic person on the planet, you do have to think you may lose, the guy may need to appeal, so an evidentiary issue isn't that great to appeal on. But a constitutional issue is great for an appellate lawyer. It makes the standard of review lower. It's de novo. That's big court takes a fresh look. It allows you to argue a lot more. That, and it's hard to imagine, some of our state courts are not as kind to defendants as our federal courts. So you've got to federalize things as well, not just with your state court constitution, but your federal constitution as well. Easiest way to do that when you're typing in your brief is just to put that little, your motion, your little constitutional law, U.S. Constitution, and whatever your state is. It gives an appellate lawyer so much more to work with, and doing habeas work as well. It's just a nice, smoother transition in, and it allows you a lot more success for your clients. Okay. Oh, pretty good. So it's 12:59. It's 12:59, so you can get out of here by 1. Any questions from anyone? Okay, you're saying, gosh, we've got 17 seconds. Okay. Okay. Oh, Dan says I do not look in ladies' purses.
Even though she said about the purses, I think
okay.
She really deserves another round of applause.
Sorry I spoke so quickly. I am a fast trade, but I did want to keep an eye toward. I knew you guys wanted to get out, and so have a great rest of the week in Aspen. Oh, yeah. Hey, no problem. Thank you.
Thank you, everyone. It's free time until the party tonight.
Yay!
Enjoy your day in Aspen.